Okay, I think we can proceed. Well, dear participants, colleagues, friends, I would like to greet you all at the fourth and last thematic session of the conference. Title of the session is The Company and its Stakeholders, External and Internal Aspect. I'm Zvonimir Shafranko, and I will be your host during this session. Before we start, I would like to ask our speakers to turn on their cameras so everyone can see you, and so I can briefly check if everyone is here with us. And also to prepare your presentations if you are using one. Also, a short reminder to honor the time that is given to you. So around 15 minutes for each speaker. If there will be any questions for our speakers, please do not hesitate to address them in the chat. The answers will be given, and I hope so. Discussion will be developed after we hear all our speakers. As the name of this session indicates, it is quite general and covers broad field of legal issues. Perhaps as such, it will give us a good opportunity to close the conference in the best manner and to craft some general considerations and conclusions. The session itself is composed of 6 interesting topics. So in next 2 hours, we will be dealing with the purpose of the company, the impact of the shareholders' agreements to corporate governance, exclusion of members from limited liability companies, appraisal rights in the context of companies' cross-border operations, corporate sustainability reporting, and CSR aspects of labor exploitation. Well, let me now introduce our first speakers. Assistant Professor Antun Bilic and Professor Nina Tepic, both from the Faculty of Law, University of Zagreb, Department for Commercial and Company Law. They will argue on what is the purpose of the company. Nina, Antush, please, the floor is yours.
Okay, thank you, Zvonimir. I hope that you can hear me all. I will deliver the presentation, of course, on behalf of us too. But of course, Nina is somewhere here and she can and will also participate in the discussion. So feel free to ask. So, I'm sorry. So we have actually heard a lot about company or corporate purpose during the last 2 days. We have heard it in connection with sustainability, digitalization, and other ESG factors. We have heard the challenges towards corporate purpose and how the corporate purpose changes through time. But now it's maybe a good opportunity actually to hear what that corporate purpose is, that we can see what is that, what has potentially changed. So the issue is very wide-ranging, and there is a strong debate going on worldwide. What is the exact purpose of a company? And this can be simplified in 2 leading theories, 2 leading models, which are well known. One is a so-called shareholders approach, which states that a company is actually managed primarily for its shareholders, so the investors. And the other competing approach is a stakeholder approach, which gives more weight to everyone, to all constituencies that actually can participate in life of a company. This also includes workers, but also creditors, chains, upstream and downstream, also the whole society and even the environment. And now we have to see which model to prioritize. should one model be given priority? Of course, some people say this debate is a bit moot because in long term, all of those groups have similar interests. And this is true. However, there are certain situations in which we have to choose. In some business situation, there is a zero-sum game, and we have to know from a corporate perspective, what is the true purpose of a company? Who should be given priority? Shareholders, environment, workers, or somehow their interests should be balanced, but how much? Based on what criterion? So we do not pretend to give a final answer to that debate because it's very wide, worldwide, but we wanted to give an answer or start giving an answer from Croatian law perspective. Interestingly, not many people have written in Croatian law about that. So we analyzed basically very basic provisions of Croatian company law to see what is the company purpose. So I will divide at least the first part of my presentation to 4 major criteria that we actually located, 4 major elements, what should be decisive. And this is actually, what is a company? Who are company actors? Then what is the guiding principle for those actors to act in the company? And finally, what about the risk allocation? So as to the first element, first criterion, what is a company? Well, it's quite simple. It's universally recognized and in theory and also in statutes that a company is association of several persons, company members or shareholders if you want, who join together, enter into a contract in order to realize a common purpose. Joint stock corporation or a public limited company, which will be primarily dealt with in this presentation, they are defined as a commercial company in which shareholders participate in the share capital with their shares. So quite simple, if we look at the definition, of a company, we can see that company is defined, it derives from its members, its shareholders. No one else is mentioned, not even directors or boards, much less abstract stakeholders. Company is created by shareholders in order for them to achieve a certain purpose. So we already have a question, can somehow this purpose be taken away from shareholders who have actually decided freely to create such company? So I would dare to say that at least according to this first criterion, shareholders have a certain priority, at least. Now, let's see who is actually company actor. So a company actor, by that term, we actually mean persons or organs who participate in corporate governance. Of course, company enters into many relationships and has dealings with wide range of people. However, that should not distract us from the fact that only some people have a say in company matters, not everyone. So who has a say in company matters of a joint stock corporation? Well, primarily it's boards, management board and supervisory boards, but also the general meeting where the shareholders are. Shareholders decide on all major issues of a company. They actually appoint boards, at least supervisory or board of directors. They decide on many most important things. They give discharges, they decide on the allocation of dividends, on the payment of dividend, on perhaps even if company ceases to exist, they retain all the main powers. Even more realistic assessments realize that even the directors who are independent, but they have to be deferential towards shareholders, because after all, if shareholders do not agree with directors, in the long run, it is more likely that shareholders will prevail. Shareholders cannot be, they're not appointed, they cannot be removed. They freely decide whether to sell their shares. On the other hand, everyone else is termed by company law to be a third person. So this is a very common and umbrella term in Commercial Companies Act. Everyone else is a third person. So we have shareholders, boards, and everyone else. This doesn't mean that those other people, third persons, are somehow less relevant or less important. Usually I say to my students when I teach company law that actually the most important principle of company law is the protection of third persons. Third persons have a priority over company assets before the shareholders. Absolutely. So commercial law is very much a protective law towards third persons. But nevertheless, those third persons are not company actors in the sense of corporate governance. And there is no contradiction. Actually, it makes sense. They are protected precisely because they are not company actors, because they have no say in company matters. So third persons are protected even by company law, not to mention other areas of laws such as labor law or I don't know, maybe tax law or environmental law. They are protected, but they are not corporate actors. They cannot decide on what happens in a company. So this is also a reason maybe also for a bit of a shareholder model. A slight maybe difference is to be had in regard to the employees, workers. They have a certain say in company matters, but still their say is relatively marginal, at least in Croatian law. They can appoint one member of supervisory board. They have workers' council who can participate, but they do not exert a decisive influence. But yes, if anyone from typical stakeholders groups should be taken into account, this is employees, definitely. So going towards our third criterion element, what is the guiding principle for managing the company? So first, it is important to mention that all persons, all corporate actors who act in corporate governance, they should follow corporate purpose. Corporate purpose is not some abstract philosophical notion. It is a practical notion which gives criterion to everyone how to act. For example, management board directors, they act as prudent businessmen, but towards what? Well, towards achieving company purpose, and we have to see what is that. So it is not sufficient to say with which due care they act. We also have to know direction, their goal. The same applies to supervisory board. Supervisory board supervises management board, but also in the interest of a company to achieve company's purpose. Even shareholders themselves, they're not entirely free to do whatever they want. They're again somehow bound by company purpose. And why? Well, because they entered into the agreement initially, into the Articles of Association. They undertook the obligation of loyalty towards each other and the company. So actually, the company purpose is the overarching principle which ties together all corporate actors. And what can we derive from that? Well, company purpose, although abstract, it has to be a workable criterion against which courts can decide whether someone did its job. For example, if there is a lawsuit against the director for the damages, the court has to assess whether this director acted in the right way. And corporate purpose is actually a very important element in that. Whether the director, as a prudent businessman, strived to achieve the company purpose. So we have to be careful not to make company purpose too vague. And the major problem with stakeholder concept of company purpose is that company purpose becomes really, really vague. There is a vast number of potential stakeholders, and it's very difficult to make sense how to balance their interests, which way to give to each interest. Some people say, especially advocates of stakeholder models, that a balance should be achieved and the directors have discretion. Yes, of course, the directors have discretion and there should be some balance, but which type of balance? What weight should be given to each of those interests? Should priority be given to stakeholders who are closer to the company, for example, employees, or priority should be given to the one who is the most needy, for example, the environment, or I don't know, poor people, or someone else? And what weight should be given? What is the common denominator to actually make sense of all of their interests? If we just say directors have to balance in their best discretion, we didn't actually say much. I really cannot see how a court can make sense out of that. Except in cases of clear collusion of directors with someone else, everything else should be actually acceptable under that, such a broad criterion, and maybe we do not want that. What about the allocation of risk, which is a final maybe element that we took into account? Shareholders, they face a risk of their investment. They invested money, and if shareholders drop in their value, they actually lose money. Very simple. Well, the counter argument goes that other stakeholders also suffer some risk, and that is entirely true. This is especially evident with employees, but also, let's say, environment. Everyone which has a contact with the company suffers some kind of risk. The larger the company, the larger the risk. However, it is important to note that those risks are not of the same kind and should not be necessarily protected with the same instruments. Let's just compare shareholders and creditors, company creditors, especially company employees. So shareholders bear the risk of company profitability. If company is not profitable, they lose value of shares and they lose dividend. They will not receive dividend. On the other hand, creditors and employees, they do not suffer that risk. They have claims against the company, which they can enforce no matter whether the company is profitable. The only situation in which they cannot enforce their claims is if company goes bankrupt, if it becomes insolvent. So they also face a risk, but a different kind, I would say lower risk, the risk of company solvency. So these are different types of risk that are protected by different, or should be protected by different types of legal instruments. I would dare to say that we do not gain much if we cram all those different risks and interests into the one notion of company purpose. It is already abstract as it is. Even shareholder model is not that simple if we want to go into that. So in our opinion, and we have to be quite clear about that, we actually believe that Croatian company law prefers a shareholder approach. It's in its provisions. And before we get crucified for such, let's say, backwards and even Friedman-esque way of thinking, we have to make a very important statement about that. This is not a political statement. This is not whether we prefer shareholders or stakeholders. This is not some kind of capitalist manifesto. This is just about legal instruments who should protect each group constituency of stakeholders. Stakeholders should absolutely be protected, but there are better tools for doing that. And in our paper, we have mentioned two of them, very important tools. One is so-called top-down regulatory approach, and this is where the state intervenes and makes certain compliance regulations, forces companies to comply. And in our opinion, most of those directives made by the EU, brought by the EU, even proposals, for example, CSDD directive, they're actually more of a compliance nature. They do not touch that much company purpose, in our opinion. Of course, we can elaborate why we think that. And the other tool for protecting stakeholders actually comes from markets themselves. If customers are conscientious enough, if they care about the environment, certain ESG factors, they will buy products who comply with that. And of course, directors will get the hint, and they will produce more such products. They will shift maybe their production methods of the company towards ESG goals. But we simply believe that company purpose is not the right mechanism to do that. Company purpose is a very old mechanism, and it survived many changes, couple of hundred years, different legal systems, different ways of doing economy. And of course it should adapt, but we are not sure that the right way is to say simply that the company purpose itself changed. Circumstances change, and there are different ways how to achieve company purpose. But the company purpose itself is, we believe, still quite firmly rooted in its company law corporate roots.
Anton, if I may interrupt, your time is almost gone, so please jump to conclusions.
No, actually, you did not interrupt because this was my conclusion. If it wasn't obvious enough, but yeah, maybe one final conclusion sentence when you reminded me of that. So company law and company purpose, they're matters of private law, what people want, what shareholders want. And of course, this freedom has its boundaries, but not within company law itself, at least not within company purpose. Those boundaries have to be set, but with different legal instruments. So yes, definitely, let's talk about stakeholders, but maybe not through the instrument of company purpose. Thank you, Zvonimir.
Thank you, Anton. I sincerely hope that you managed to provoke those participants who support the stakeholders approach. So we will have a nice argument afterwards. Okay, our next speaker is Mihaela Braut-Filipovic. She is associate professor at Department of Commercial and Company Law at University of Rijeka Faculty of Law. And her topic is how shareholders' agreements shape corporate governance and directors' liability. Mihaela, please proceed. The floor is yours.
Thank you, Zvonimir, for the nice announcement. First of all, I want to express a warm thanks to the organizer of the conference, which is so interesting so far. Okay, so now I will share my screen because I'm going to use a presentation. And if you could just confirm if everything is okay. Yes, yes, it is. Okay. Well, the topic which I chose for today's presentation is a broad one, and I should really do my best to only point the most important points in the research. My research consists of four main topics or theses, and I shall try to tell you about the most important things for each of them. The first thesis was, which I took in my research, was contract law or state corporate law. Which one gave birth to modern companies? Okay, this is nothing new. This is a very old debate. And since we do not have the time to enter into it, I will say that for the purposes of my research, I concluded that I shall focus on the interplay between state corporate law and contract law in shaping the today's corporate governance of the companies. I will proceed with my second thesis, which is kind of a central one of this research, and that is shareholders agreement versus articles of associations. Within it, I posed two main research questions. The first one was, can parties and content of shareholders agreement and articles of association overlap? Well, as to the parties, the conclusion was very simple, because yes, all shareholders are free to conclude shareholders agreement, in which case we would have the same parties who concluded first articles of association and then after a shareholders agreement. However, both practice and theory absolutely supports that only 2 or 3 shareholders can actually enter into shareholders agreement. Also, even a third party, potential investor, creditor, can be a party to a shareholders agreement. Also in practice, it's seen that even the company itself can be a party to a shareholders agreement. So the parties can totally overlap or only partially. In theory and in practice, it's supported the view that at least one shareholder must be a party to a shareholders agreement. As to the content, well, let us start with the articles of association, which most modern corporate law strictly say which is the mandatory content of the articles of association. In that regard, we are much more assured into what we can expect. On the other side, shareholders agreements are in most countries simply not regulated. and their content is thus really almost unlimited. Of course, it is limited, and I shall go to those points later on. But for this research question, my finding was, yes, the content can overlap, and in fact, we can have a conflicting provision providing the same thing but different solutions in articles of association and shareholders agreement. This led me to my second research question, and that was, okay, if they can overlap and we can have a conflict, what do we do in that case? Can shareholders agreement actually modify the articles of association? Is this something that can lead us to answer the question, which will overrule articles of association or shareholders agreement? I know that the primary answer would be a big fat no. Shareholders agreement cannot change under any circumstances article of association. However, I put that into a question, and in fact, I believe I have found one scenario under which it would even be possible that in case of conflict provisions, the court would be simply forced to actually ask the true will of the parties. Now, in order to even go into that possible scenario, we must say that the legal nature of articles of association is not a clear matter. But most of the scholars would agree that it is a type of an organizational contract. So it is a contract with many specifics and many limitations and so on and so on. Unfortunately, we do not have time to enter into it. But if we look at it as a contract, which is a prerequisite for this scenario, then if the parties would want to change, modify the contract, you will need a unanimous consent of all of the parties. So the first step would be that we have all shareholders who actually signed the shareholders agreement after they, prior to that, they already have the articles of association and they established the company. Then, when we look at the content of the articles of association and the shareholders agreement, we must differentiate that if we have mandatory provisions which are set so in state corporate law, then there is no place to conclude that the parties actually modified it, because the rules of modifications of articles of association and then to mandatory provisions are firmly set in state corporate law. But in articles of association, shareholders can put some other clauses as well. Under these facultative provisions, we can find also and some contractual clauses like arbitration clauses, composition of manager board, and so on. And this type of clauses, which are in its legal nature contractual, can be further changed by the parties. And if all shareholders who are also shareholders, and they also participate in concluding a new shareholders agreement, which regarding the same topic has a different solution, then indeed, we do have a case where a court should be obliged to question the true will of the parties and the possible conclusion that the subsequent contract shareholders agreement can actually change the articles of association. Now, rest assured, I do think that this will be really a very narrow situation. And for most of the cases, we have the conclusion that shareholders agreement or any other contractual mechanism, in fact, cannot change articles of association except for this scenario which I presented. And that led me to my further, my next thesis, and this is, can shareholders agreement affect corporate governance of the company? Well, the practice says big yes. We have increasing number of use of shareholders agreement. I mean, regardless of the amount of the big numbers in which this is used, it's surprisingly how this topic is seriously undermined in scholarly writings. And it seems like shareholders agreements exist somewhere else, not within the corporate law. And that is actually the point which I will address even more because I think it's quite concerning. Anyway, we do have shareholders agreement. They are in most cases valid. From a couple of studies which were conducted, it seems that shareholders try to obtain a control, and the primary goal refers to the management of the company, and in that it's primary to elect or further to the right to revoke the manager. That is of their most interest. Now, I pose myself to subsequent questions to clarify the situation of the fact that we have a contractual mechanism completely outside of the state corporate law, and to see what is its actual real effect on the corporate governance. So, can shareholders modify, default corporate rules? So these are the rules which are not mandatory, equally by articles of association and by shareholders agreement. In here, I must say that the biggest difference between articles of association and shareholders agreement is the legal effect, and that is the shareholders agreement shall be held binding only on shareholders which actually signed it, on the contractual parties. This is the main difference. And I think it's a really big and strong point. Of course, there are some things that if you put in the shareholders agreement shall be void, or simply will not produce any effect towards the company or third parties. And this will be these limitations which I put here, two categories: mandatory corporate rule, and second, those rights which some national legislator provided. Yes, you can modify them, but only via articles of association. And I put forward here the example in Croatian law, but there are many more examples in Croatian law and in comparative as well. So we have a very powerful tool. Let's see what we ask ourselves, what I ask myself later. Can shareholders modify the mandatory corporate rules by shareholders agreement that they could not by the articles of association? The primary answer is no. You have a mandatory provision. You cannot skip it. You cannot change it. However, in the corporate law, we are well aware of this phenomenon, which really has many different branches, and we could speak only about that. And that is the separation of the voting power and control. And through the shareholders agreement, the parties can actually achieve it, and even minority shareholders can have, if they act in concert, they can have significant power over the major questions in the company. So actually what I saw from this thesis is that shareholders agreement can definitely affect the entire corporate governance. What we have is that it is allowed to build a parallel system of governance outside of the state corporate law by the contractual mechanisms. Yes, we have certain limitations, but these limitations are really very broad. It seems to me that often when we talk about the corporate governance, we completely neglect the part that the parties, shareholders, enter into various contracts, especially, for example, in the capital market law, where we have investment funds which enter into the company. They do not just become a new shareholder. They enter into it by concluding various numbers of different contracts, which more or less are taking away something from the company. And this is allowed. But we, as corporate scholars, we often say, okay, that's capital market law. This is not something which is part of the core corporate law. And I would strongly disagree with it. As I said, surprisingly, there is really a very small, a very little number of scholars which even enter into this paradigm. Those who did are saying about the rise of the stealth governance. And I think this is something that should be really considered. Also, what we spoke about yesterday, sustainability directive, new movements, as my colleague previously said, corporate purpose. Yes, but we also have to acknowledge the private ordering of the parties which is taking place and see if in that we might come to some different conclusions, or should our perspective a little bit should be widened. Anyway, my final research question was, okay, shareholders agreement and directors liability, is there a connection? And yes, there is a connection. It's not such a direct one, but it can be used to affect the liability in a certain way. Now let's see in which way. Anyway, managers of the company are well known to be a part of the shareholders agreement, whether they are also at the same time shareholders or not. They often are. In the shareholders agreement, their primary goal is to affect the management of the company. Yes, probably the primary goal is towards the composition of the company. Regarding the obligations to act in accordance with something said in the shareholders agreement, generally we can say they can influence on the directors. However, it is answer will strongly depend on the legal form of the company, because if you have a joint stock company, then you have independence of the managers, entire a mechanism of fiduciary duties, duties of loyalty, which then it could pose a serious question if you have a shareholders agreement which can thus affect the director. But if we talk about a limited liability company, the doors are open. And in fact, in practice, shareholders agreement mostly are used in these private companies. Also, although they're often and more often used is also for the public companies. So this is something which we must put in regard. So is it possible to modify the director's liability through the shareholders agreement? Well, first of all, as we heard yesterday, as we all know, director's liability is not harmonized on the EU level, but there are studies, and director's liability is actually a mandatory framework of corporate law. You cannot limitate director's liability. However, there are strong movements across the ocean to limit some aspects of that liability, and most of them are in the way of limiting the amount of possible monetary damages and duty of care claims. And the Delaware, of course, who else than Delaware, have developed a possibility which was further on adopted in other US countries, limitation of the duty of care, where in charter they can limit certain director liability for monetary damages. And this is important because he still remains liable, but the amount of the monetary damages is limited. And also what is quite concerning from our view is that from 2000, it's even possible to, under certain conditions, it's not a general waiver, but they can waive in their charter or elsewhere a doctrine of opportunities, which strictly plays with their duty of loyalty, although they will always say, no, duty of loyalty or fiduciary duty, you can never limit it. But in fact, through the small doors, under certain set of conditions, it's actually allowed. Now, we already witnessed how US law can influence the continental Europe. So this is something which will come on our table, and we will have to have an opinion about that. In each case, it already came in Germany, where there were strong voices that liability of directors is too strict. It should be allowed to be limited, all in the aspect of the compensations. Now, what already is
Michaela,
possible.
excuse me, just please, if possible, jump to the final.
Okay, yeah, I will. Yeah. Well, okay, director's liability, it's possible to limit some parts with insurance policies, indemnification clauses, and that can be also inserted in shareholders agreement. So that is my link. As to the conclusion, I think that use of shareholders agreement can pose serious concerns. It is unequal treatment of shareholders and transparency of governance. Equally, I call all of us here and corporate scholars to involve in our findings, in our rethinkings, more of these private orderings, which are being used by shareholders and often, to me, seems neglected when we speak about the corporate governance of the companies. Now, this is what I wanted to say, and thank you, Zvonimir, for your intervening. intervenient.
Okay, thank you very much, Michaela. Well, it's interesting to see how our moderators are very strict with time when they are moderating sessions, and when they are discussing, they're much more flexible, right? Well, it's human nature, of course. Okay, now I would like to announce Associate Professor Tomislav Jakšić, also member of Department for Commercial and Company Law at Faculty of Law in Zagreb. Tomislav will share some info and his thoughts on exclusion of shareholder from LLC pursuant to Article 420 of Croatian Companies Act. Well, Tomislav, please, the floor is yours. Proceed.
Thank you, Zvonimir. Well, I was a moderator in the last session, so I will try to be mindful of the time as well, because I was quite strict with it. So the topic of my presentation is exclusion of a shareholder from the LLC. This is actually a work in progress, and the idea of my presentation is just to tackle the interest in this legal instrument, which I personally consider very important and mostly underrated, since it has significant aptitude for use as an important corporate governance tool. So what is generally exclusion of shareholder? The exclusion is a process resulting in the banishment of a specific shareholder from the company, while it does not touch upon the existence of the affected share. In other words, the share remains. The share and the deriving rights and obligation are therefore unaffected by such exclusion. So limited liability companies are normally considered to have smaller shareholder numbers, and since it is normally also expected from such shareholders to personally contribute to the commercial success, as my co-colleague mentioned, purpose of the company. Therefore, in that regard, limited liability companies are more similar to partnerships than to public limited companies, which on the other hand are considered to represent typical corporations and commercial companies. In this regard, LLC company law rules actually give an upper hand to the shareholders and not to its management, meaning that usually an LLC management is dependent upon the shareholders' decision. The best example of this is the rule on the shareholders' right to pass mandatory instructions to the management, and the management is obligated to follow. Once again, this is not something that is available to the public limited companies and to the shareholders of such companies. Since limited liability shareholders have such an important role, the limited liability shareholders structure is also something that is much more important than the shareholder structure in the public limited company. It is generally recognized for all corporations that the shareholder structure is a sanctity in a way which cannot be unilaterally altered, meaning without consent of the affected shareholder. However, there are exceptions. Most prominent one is exclusion of the shareholder from the company because he failed to pay the share capital contribution in due time. One important exception native to the limited liability company, which is also the topic of this presentation, is the possibility to exclude a shareholder on the grounds other than the failure to pay such a capital contribution. Such possibility forms an important utility of internal corporate governance, since its use could alter the shareholder structure. Exclusion is, as Zvonimir mentioned, regulated under the Article 420 of the Croatian Companies Act. The rule on exclusion actually recognizes two situations, two pathways which can lead to the shareholder exclusion. The difference between the two lies on the fact whether the companies articles of association contain specific rules on such exclusion or not. In my presentation, I will mostly focus on the first situation where such rules on exclusions are indeed included in the company's articles of association. Therefore, if the articles of association contain such rule on exclusion, the resulting situation is considered to be a result of the shareholders' autonomy, which binds all shareholders since they all have to agree to such an exclusion mechanism. However, such rule does not only bind the shareholders existing at the moment of rules introduction into the company's articles of association, but it also binds all of its future shareholders. This might seem unfair to the future shareholders since they did not expressly agree to such a rule on exclusion from the company. However, you could say that such future shareholders inherited the legal position of the previous shareholder who agreed on such a rule. It could also be said that they at least impliedly agreed to such exclusion mechanism by accepting their shareholder status and all the rules contained in the company's articles of association. The advantage of having such an exclusion mechanism is that shareholders could determine themselves the conditions, the procedure for such exclusion, and the consequences resulting from the shareholders' exclusion. In other words, shareholders are awarded great autonomy in modeling the exclusion mechanism. This especially relates to the conditions for the shareholders' exclusion, meaning that the shareholders could be removed from the company due to any reasons contained in the articles of association. We will see whether there are any, maybe some limitations in this regard. Such reasons, it seems, need not to be in the interest of the company's well-being, but in the interest of specific shareholders or a specific majority of the shareholders, or could even be based, although unlikely, on the decision of the company's management for whatever reasons that may be. Such rules could also ensure that a certain shareholder structure is preserved. They could also ensure that certain goals, company purpose, for example, as well, goals individual or common to more persons, private or public, are achieved. In other words, such rules could internally tailor the company, which could also be reflected externally in dealings with third parties. However, one cannot but wonder whether there are some limits to such autonomy, and if there are, what are those limits? Presumably, these limits are very narrowly construed and follow the same limits as those imposed on the party autonomy under the Croatian Obligations Act, which might seem, I will now quote my colleague Anton, backward and frugal in this regard, because it, as already mentioned, might seem that certain or the other shareholder or the shareholder that is being excluded is being treated unfairly, or that the interests of the majority are not taken into consideration, and so forth. The other, besides this first situation where we have the rules for the exclusion or the exclusion mechanism included in the Articles of Association, later on, the Croatian Companies Act also recognizes another situation. The other general situation is actually where there are no such rules included in the Articles of Association, and it is a general rule of the Companies Act, where a shareholder could be excluded from the company due to the existence of an important reason for his exclusion. However, unlike in the previous situation, such reason has to be connected to the company's well-being. In other words, Words, it must be in the company's overall interest to exclude a specific shareholder. Furthermore, the shareholders' exclusion must be a measure of last resort. In other words, the company should not have any other measure at disposal for the handling of the situation or the resolution of the issue at hand. For example, some of such measures might present themselves as a removal of the shareholder who is also appointed as the member of the management board, or even more common in everyday situation is deprive the shareholder of its right to be informed about the company's affairs. This second limitation actually only limits further the shareholders' exclusion from the company, meaning that actually emphasizing the importance of the first possibilities of the first situation. Along with other limitations not named during this presentation, it actually means that such second situation will only be viable in the most extreme situations, where a specific shareholder intentionally or unintentionally severely damages the company's interest and his ability to achieve the company's goal. Well, I will conclude with this notion, having in mind the time that I still have some of it a bit left, is that the possibility of the shareholders' exclusion, either the one described in the first or the second option, but preferably the first option, is more preferable because it leaves much more freedom to the shareholders. It also represents an important tool of internal corporate governance since it affects the core of the limited liability company, its shareholder structure. Thank you very much. I will be open for any further questions later on. Thank you.
Thank you, Tomislav. I will now proceed with our next speaker. I want to welcome Paula Deval-Talens, who is assistant professor of business law at the University of Valencia. Paula will discuss the shareholders' appraisal rights in EU cross-border mobility. Paula, please, the floor is yours.
Thank you. Thank you. Thanks for the kind introduction. It is my pleasure to be part of this 5th International Conference on European Company Law and Corporate Governance, and to see so many familiar faces. For that, I am truly grateful to the organizers. As pointed out, my contribution deals with shareholders' appraisal rights and in cross-border mobility, and I would like to share my presentation with you, which is there. For the purpose of the presentation today, I thought I would provide a little bit of framework before focusing on the two issues that I would like to discuss today, and which are quite restricted and do not cover all the issues arising from the directive. So as you may know, the directive that I will call today on cross-border mobility, which is the one dealing with conversions, mergers and divisions, and amended the so-called codification directive, needs to be transposed into member states before the end of January next year. Among the intensively discussed issues within the directive, I would say that the protection of stakeholders, and in particular the protection of minority shareholders opposing the transaction, lies at the heart of many debates. This is because for the first time, the legislator of the European Union has enacted one very specific protective mechanism, which takes the form of the right to dispose of the shares for those shareholders that are opposing cross-border within the EU merger, conversion, or division. This is an exit or sellout right. It is important to bear in mind that the directive is a minimum harmonization one, which provides quite a lot of leeway for for member states to implement it, and this touches upon shareholder protection as regards the sellout right. As a minimum harmonization standard, the directive only foresees or only requires member states to provide the right to shareholders opposing the transaction, and only to the extent to which the transaction entails a change in the lex societatis. This is in the applicable law to the company. So if one thinks about it, before the cross-border mobility directive, quite a lot of convergence existed among many member states. Many of them were already familiar with sellout rights as a protective tool for minority shareholders already after the so-called cross-border merger directive back in 2005. As far as I'm concerned, this was the case with Austria, Germany, Italy, or Spain. And some of them, in particular Spain, already was foreseeing the right for cross-border conversions, which were actually regulated or have been regulated for a number of years now under Spanish law. I would say that in light of these conversions, the EU legislator opted for creating the right as a minimum harmonization standard. But I would also say that after dealing with the issue, conceptual but also enforcement differences exist at the domestic level. So if one compares what we could call German influenced models, here German law and Austrian law, and what they call the Abfindung system, to Roman Latin jurisdictions such as Spain or Italy, some conceptual and enforcement differences arise, although I would also claim that these differences may be easy to overcome within the next few years. So the provisions that you can see on the screen within the directive regulate the right, the sellout or exit right, with quite an amount of detail. And they do it with a strong German-Austrian influence. So the Abfindung model in these jurisdictions has made its mark into the directive. I would say that the pen that drafting the original version of these provisions was held by an Austrian hand. And this German-Austrian Abfindung influence can be seen in two examples that I will like to share with you today. So the first one is a very easy one, and that is, for instance, that the company that undergoes the transaction already, when drafting the draft terms of the transaction, needs to reflect, to include in that document the cash compensation that it offers to potentially dissenting shareholders. This mechanism, which is an ex-ante one and makes that the company bears the cost of assessing valuation at an early stage, is not common in Roman Latin jurisdictions. So we're not familiar with that system. The second one, maybe a more important one in terms of a conceptual approach to the right, is the fact that the directive, when protecting through sellout minority shareholders, does not actually foresee just one right. It has a twofold approach, which is typical from German-oriented systems. On the one hand, it awards a sellout right, the right to dispose of the shares against adequate cash compensation, and at the same time, it provides shareholders declaring the will to exit with an appraisal right, so the right to ask in front of a domestic authority to provide additional cash compensation in case that they believe that the compensation was not initially properly set. So this is a twofold approach with which many Roman Latin jurisdictions are not familiar. With this framework in mind, and for the purpose of my presentation today, let me move to the second issue. You will see that these are two issues that are not specifically connected among each other, but I thought they were two that could be discussed from a quite horizontal perspective, and many countries would be familiar with them. So this second or first issue I would like to discuss today is the relationship between the sellout right / appraisal right within the cross-border mobility directive and the freedom of establishment. So the relationship between this derivative law piece and primary law. When one looks at minority protection from the perspective of the treaty of the fundamental freedom of establishment within Article 49 of the treaty, one immediately knows that minority protection qualifies as an overriding reason in the public interest. This is what we call within the freedoms a so-called implicit justification of a restriction to the freedom, here to the freedom of establishment. And if you're familiar with the case law of the Court of Justice of the European Union, you may know that the court has repeatedly declared that this kind of overriding reason in the public interest to protect shareholders does exist theoretically, but it has never actually accepted the effective application thereof. In any case, there's no company law case accepting that this justification is applied. This is, by the way, the same one protecting creditors and employees from the company law perspective. You have the references to two cases in which the court actually mentioned the justification, but never actually granted its application. What I wanted to discuss here is that if we take into account that the directive is a minimum harmonization one, what happens is that whenever transposing the sellout right, member states are going to be bound by derivative law itself, but also by primary law, by the freedom of establishment, to the extent to which they would want to go beyond whatever the directive foresees. And what would concern me the most is that when apply their provisions, their domestic provisions on minority protection via this sellout right, they're going to need to comply with what we call the proportionality test. This is the requirement that a justification needs to fulfill to be compatible with the freedom. And to overcome, to fulfill this proportionality test, the Court of Justice has laid down two requirements which are generally known. The measure adopted by a member state would need to be appropriate and it would need to be necessary. A measure is appropriate whenever it is adequate to fulfill the goal that it pursues, while a measure is necessary when the member state may not use a different means to achieve the same goal. So my assertion here is that when drafting the provisions on the sellout right in the directive, the legislator in most cases was careful enough as to preserve the proportionality test. So already derivative law is usually consistent with this proportionality approach. And I would like to provide you with two examples once more. The first example is a very easy one. So within the directive, the approach taken by the EU legislator is that the sellout right is granted after an active behavior by the exiting shareholder. This is seen in the fact that they would need to vote against the transaction as a minimum harmonization standard, and also in the fact that member states could require them to declare their will to exit the company even before the general meeting. So this is in line with trying to preserve the rule from restricting the freedom of establishment any further, under the general assumption that the sellout right itself is a justified restriction to the freedom. The second example is more controversial, and it refers to the moment from which the cash compensation against the shares should be paid by the company. And this is a controversial issue because the EU legislator did not include a rule on the dies a quo. This is on the moment from which the compensation shall be paid. It simply provides a dies ad quem, this is a maximum amount of period in which the payment shall be made. And this is 2 months after the transaction has taken effect. However, many Roman Latin jurisdictions, specifically Spain and somehow Italy, but this depends, are not familiar with this ex post system, but rather have an ex ante system. This means that before the transaction takes effect, and actually before issuing the certificate that is necessary for the transaction, they require that the payment of the cash compensation is made. And this is a more restrictive solution to the freedom of establishment, because the transaction may not take effect as long as the company does not pay. But I have sustained that the way in which this hampers the freedom of establishment or the proportionality test is not a very serious one. And I rely, although I would not want to get into great detail today, on the minimum harmonization standard, which is quite a weak argument, and I acknowledge that, on the way in which the several versions of the directive have been drafted, and in the fact that it is a very nuanced restriction if what it is required to be paid in advance is just the amount as regards to which there is full consensus between the company, because it derives from the offer and the acceptation or the acceptance by the shareholder. But I understand this is a controversial approach. The last issue I would like to briefly discuss with you today refers to the economic rationale of the right. If one takes a look at the available evidence, I would resuming it in two sentences. First, empirical evidence suggests that minority protection operates as an incentive to cross-border mobility. And second, that usually the resulting company of such a transaction is domiciled in a country with a higher level of protection. For this reason, it makes sense to harmonize with a very protective mechanism, at least to prevent EU companies domiciled in member states from being the target of this kind of operations, and rather being the ones promoting them or enhancing them. The second and last issue I would like to discuss in this regard are for us to see what market failures arise from the transaction itself and how the exit right may mitigate them. The first one are agency conflicts, because prior literature indicates that many of them have so-called distributive effects. This is the majority which initiates the transaction, looks towards benefiting from it in different ways. For instance, because the new law would be more favorable towards related party transactions. And the idea is that by including the exit right, the agency conflict would be limited to the extent to which it is very difficult to tell apart from an ex-ante perspective what transactions are distributive and therefore inefficient and which of them not. Even from an ex-post perspective, that is usually difficult too. The second market failure arising here regards the liquidity, the risk that the investment of a minority shareholder is captured at the state of destination. But I would claim that liquidity is not the greatest concern of the EU legislator, because within the prevailing view in the European Union, liquidity is not at the base of the exit right. So we do not have such thing as a sellout exception or a market out exception, which means that whenever the company is a public listed one and the shareholder may directly disinvest, we still grant the right within the European Union. So liquidity is not as relevant within the internal market as it is, for instance, in US jurisdictions. The last point I would like to raise here regards information asymmetry. So minority shareholders usually confront asymmetry because they are not as familiar with the lex societatis of destination, and they may face obstacles to exercise the rights or even to be familiar with what authority would protect them at the state of destination. It is also true that usually companies undertake these transactions in the European Union whenever they have identity common signs, language, common legal tradition. But here, what would concern us is that the exit right is aimed at mitigating the lack of information that minority shareholders may have at destination. As you see, these are very general issues that directly concern the provisions that we now have in common. And although we have a short period until transposition, there are many issues that are still going to be discussed for a long time after the deadline ends in January 2023. I would like to end my presentation here and remain available for the discussion after that.
Thank you very much, Paula. Our following topic, according to the plan, should be corporate sustainability reporting and corporate performance. But I think we don't have the speakers with us at the moment. We have, in fact, the last minute maneuver because Dr. Zsigman and Dr. Rizak has to excuse themselves due to some unexpected circumstances. Anyway, I suggest we proceed with our next speakers, and we will see if one of the speakers I mentioned before manages to join us before the end of the session, and then perhaps we will give them some time to give their speech. Okay. Lastly, for now, at least, I would like to announce Professor Sandra Laleta, who is full professor and head of chair of Labor and Social Security Law at Faculty of Law, University of Rijeka, and her assistant, Ms. Karla Kotulovsky, who is also a PhD candidate at Faculty of Law in Rijeka. They will elaborate on CSR and combating labor exploitation. The questions they are seeking to answer is what more can be done in Croatia regarding that issue. Professor Laleta, please, the floor is yours. Please unmute yourself.
Is it? Hello?
Okay.
Is it,
Okay, we can hear you
hear
now.
me now, yes.
Please proceed.
Thank you. Just okay. Dear colleagues, ladies and gentlemen, it's a privilege to be here today and to hear so many interesting talks. I would like first to thank the organizer for the opportunity that my colleague Karla and I participate in the conference. Today, the companies claim to protect human rights, to focus on modern or contemporary slavery in their business operations and supply chains. Nevertheless, the world of labor is faced with increasing labor exploitation. What is labor exploitation? What is modern or contemporary slavery? According to the International Labour Organization, indicators of exploitation include, as you can see on the slide, bad living conditions, excessive working days, hazardous work, low or no salary, no access to education, no respect of labor laws or contracts signed, no social protection, and very bad working conditions. On the other hand, term contemporary or modern slavery is widely accepted as a broad, non-legal umbrella term that refers to, but is not limited to, a range of abusive practices such as forced labor, bonded labor, human trafficking, child slavery, traditional slavery, forced marriage. The term modern slavery is often associated with the traditional slavery and or with just mentioned severe forms of exploitation, thus leaving aside other exploitative practices. And therefore, to focus more broadly on labor abuses is also important, as it is not always clear at what point non-compliance with labor standards seeps into cases of criminal exploitation. We deem that such an approach is appropriate, necessary, because every labor abuse or labor exploitation should be recognized, prevented, and sanctioned. Among scholars, it is widely accepted that modern slavery should be conceptualized as part of the continuum of exploitation that are context dependent. Namely, working conditions of people can gradually worsen, what can in turn result in modern slavery. Corporations carry their part of responsibility. Corporative social responsibility, we have heard much about it, seems to be a magic model developed with the purpose to make enterprises socially responsible and to respect human rights, workplace diversity, safety, environment, etc., in their business operation. Supply chains define the structure and operation of contemporary business organizations. In global economy, supply chains can be found in every industry and on every continent. Without entering into the issue of diversity and complex structure of supply chains, we have heard very much about it, especially yesterday. It should be emphasized that supply chains pressures have important implications on employment relations and labor standards. The problem of labor exploitation can be found throughout global supply chains in developing regions, in developed countries, in local or domestic value. And different studies have shown that there is a presence of modern slavery, namely practices such as forced labor and debt bondage can be found in the global supply chains, where multinational corporations are lead firms. In such supply chains, an environment can be created where exploitation of institutional deficiencies, we can call them protective gaps, and thus modern slavery can occur more often undetected. On the other side, in the creation of the domestic supply chains, the decision of the enterprise to use outsourcing is a first step to segment a single organization into supply chain spanning multiple organizations. Here, the supply chain pressures produce different challenges for both for workers and managers, both of suppliers and lead firms. Suppliers that are motivated by cost reduction often opt for low-road strategies. And therefore, it is possible to talk about the corrosive effect of supply chain pressures on the standard permanent employment tract. Research carried or that included several industries has shown that the consequences are also inferior wages and conditions, precarious employment arrangements, work intensification, and health and safety at work risks, and other consequences, especially in several industries such as construction, manufacturing, etc. Due to the lead firm's contractual pressure in the supplier firm, the absenteeism and turnover are high and the quality outcomes are poor. On the other hand, the workers of the lead firm are faced with the low morale and conflict, and they're very often afraid of losing their jobs, and that working conditions will worsen. When we talk about Croatian companies, there are some Croatian scholars that emphasize that despite the absence of civil cases, Croatian companies are becoming more and more aware of possible responsibility for involvement in international crimes and other human rights violations, and that are increasingly gaining knowledge on regulations in corporate social responsibility. To add, Croatian companies participate in different initiatives and apply different standards. Despite numerous legal sources that deal with the human rights and corporate social responsibility, such as, for example, UN guiding principles. But despite different initiatives, we think that much more has to be done. In this sense, the recent European Commission proposal for a directive on corporate sustainability due diligence represents an important step, or we hope is an important step. So we will see what happens with this directive. Since proposal directive has already been elaborated on by the previous speakers, here I would like just to emphasize some objections, or one objection made by the European Economic and Social Committee in its opinion. So the committee, I quote, pointed out the role of the state, saying that although the companies are responsible for respecting human rights, they cannot replace the critical role of the state, particularly the state duty to protect against human rights abuse within their territory by taking appropriate steps to prevent, punish human rights abuses through effective policies, legislation. Also, the committee pointed to the states and their governments' many enforcement powers that companies do not have and should never have, including inspecting workplaces. I apologize for a second. Speaking about the role of the state, I would just emphasize that Sweden has criminalized the human exploitation. As we don't have time to analyze this this law, this provision, I would, at the end of my part, say that as we have heard, and we agree also that the issue of enforcement is so important. I would like to, before giving the floor to my colleague Carla, I would like to illustrate a positive example from the Croatian case law. So our court, County Court of Split, has used the term exploitation in one individual labor dispute on unlawful dismissal that was based on the worker's non-fulfillment of the working norm. The court said that, ruled that unrealistic working norms represent harsh form of exploitation of workers and framed the base for the possible abuse that is not allowed. That dismissal in that case was based on too high and unrealistic norm that was exceeding the possibility of each worker employed by the same employer. Thank you. Now I will continue with this part, the Croatian part.
Thank you, Professor Laleta. Good day to everyone. So my part of presentation will be focusing on a situation in Croatia, a labor market with, in our opinion, good example of good practice with in the context of corporate social responsibility. So to start with, I would like to say that we can all agree that the regulation should ensure that the competitive interaction between leading firm and suppliers do not produce in adverse outcomes for employment relationship, given that unfair and unsafe working conditions can arise from opportunistic behavior by suppliers, pressure imposed by lead firms, and ineffective employment laws and regulations, which we'll focus on today in our presentation. So various studies show that strengthened demands of and expectations of the leading firms often result in suppliers, those in a weaker position, prioritizing short-term costs by intensifying work arrangements, and they are more leaning on temporary contracts. Such pressure has always been found to undermine the ability of suppliers to develop a strategic approach to human resource management. If we consider that modern slavery as a concept in a broader term, the erosion of labor standards can be related with abusement of atypical forms of employment, effectively temporary employment, and low quality of work and employment status of the worker. So in context of Croatia, migrant workers, seasonal workers, illegally employed and temporary represent the most vulnerable and marginal categories of a worker. They tend to be employed by small, lower tier suppliers, and which actually represents practical challenge to enforcement of labor standards. So because of the time, our presentation is limited. Today, Professor Lalit and I were focusing in our work on one category, which is fixed-term workers. So Croatia has a huge problem with high growth of temporary work. As we know, there are limited duration and are problematic from legal and financial point of view, besides being international factors. So they are actually very precarious, as we can see the statistics. Also, we apply, just a minute, implemented and apply directive of fixed term work, which was formulated in the context of domestic priorities to increase the labor supply, which has given the rise to most controversy. And social partners have recognized that that employment contract for a certain period of time are specific to some sectors, professions, etc. That is why when transferring directive, we must take into account the situation in each individual member state and circumstances in sectors, profession, including seasonal nature. So without doubt, this form of work is dominant in Croatia, structurally conditioned by needs of seasonality, replacement of absent work, and hiring for specific project. So the directive has two main goals. Strong focus is on equal treatment, meaning ensuring the application of principle of non-discrimination in relation to workers who work or perform their work in a definite period, while laying down the minimal requirements for the legal qualification of the contract. So regardless of that, in Croatian labor market, whether the fixed term contract is a direct determinant of the lower quality of the job, or whether it is specific to organizations and workplaces, in my research, I found that studies relentlessly indicate that temporary workers are in less favorable situation regarding quality of their jobs in relation to permanent workers in terms of material rights like salaries, allowance, and organization of working hours and absence, for instance, vacation and sick leave. And all these dimensions of so-called precariousness are not leaving this sphere, but also leaving this sphere into private life of worker. The second purpose of directive is to establish a framework for preventing abuses arising from successive application of fixed-term employment contract. And once again, we have 4 direct abuses of this institute. First, at the individual level, fixed-term work represents normalized and, as a rule, involuntary part of work experience of Croatian workers. According to labor law, contracts of indefinite duration are a general rule, and the fixed-term contracts should be only exceptional. Second, temporary work is too often in function of probationary period. Again, direct abusement of this institute, which contributes to normalization of such employment, even if it shouldn't be a contract in the first place. So if we consider European pillar of social rights, which encourages employers to transition the temporary workers in the indefinite contract form, we have another erosion of labor standards, giving the downside mobility and low rate transition to standard employment relationship. And fourth, it's about enforcement gap. Croatian workers are, as we can see here from this report, reluctant to claim their rights before the court. They're afraid of losing their job. Many workers have fixed-term work often concluded against the law, while employers patiently exploit this institute, and workers and employers are aware of dissatisfied working conditions of their workers and insecure employment status. So they are working and hoping for be offered permanent work, and of course try to do their best. So it should be noted that listed this insurance in directive are not such adequate or sufficient to combat uncertain work arrangements. Okay. Since UN guiding principle of business and human rights.
Carla, excuse me for interruption. You should be jumping to conclusions because you had so much time already.
Okay.
So please just finish.
This is the last one.
Perhaps later we can discuss something if there is something else to be said. Thank you.
Okay. So the guiding principles of business and human rights do not exclude enterprises according to their size. So Professor Lale Tanja used examples of Croatian market in context of video game industry, which is the literature described as a microcosmos of contemporary problems of capitalism and inequality, also called ruthless sector for digital age. So continuously restructuring a global value chains require greater flexibility in form of employment, tasks, and working hours. As we know, leading firms and companies invest millions in the creation of computer games and own a large number of programmers, workers, and teams who participate in this production process. As in other entertainment industries, developers who have a large budget and a strong marketing have significant advantage over the small companies, suppliers, also they called indie developers. So the distribution of risk along this supply chain can explain the difference in working and employment condition. So within the video game industry, there is a wide spectrum of different forms. Workers are employed from project to project and to obtain a specific task. So in Croatia, to conclude, this is the fastest growing economic sector, and we have numerous esteemed companies that cooperate with large video games distribution on a global level. So a big step forward in Croatian gaming industry in terms of workers' protection was made 2020 with the conclusion of collective agreement between indie gaming studio GameChuck and the new union from Zagreb, which placed a stricter condition under which fixed contract for a certain period of time can be concluded at all, and shorten the duration of the longest duration of one or more consecutive fixed term employment from 2 to 3 years. And the trade, this is very significant. The trade union has the rights to inspect contracts and annexes to fixed contracts between the employer and individual worker if he has a reasonable suspicion that employer is abusing fixed term contract. Thank you. Have no time.
Okay, thank you, Carla. Thank you, Professor Aleta. I abused my authorities as the moderator and gave the last speakers a bit more time, but I wasn't trying to be unfair toward other speakers, but rather pragmatic because as I can see, the Dr. Zsigman and Dr. Izak won't be joining us in the end, and that's it. I would like to thank all of our speakers for their contributions, for their presentations and arguments. And now I think it's time and we can proceed with this, the discussion. As I can see in our chat, there are some, there's already something discussed. So I think, as I presumed, Anton, your presentation brought us most cloudy weather here, if I can say. So perhaps Christian, Professor, excuse me, Professor Chulinovich-Herz and Anton, if you and Nina, perhaps if you can start this argument. So let's see your opinions.
Thank you, Zvonimir. If it's okay, I will answer. I got 3 questions, so maybe in the order how they were put. So first question is under number 97, basically what if shareholders opt for an additional purpose which favors stakeholders or environment or everyone? Whether this is possible, what would happen? Yes, definitely this is possible under Croatian law. Shareholders are allowed to choose whatever person they want to pursue, even in the form of joint stock corporations. So our point was merely that unless shareholders specified a purpose, it has to be presumed that they want to pursue typical person of increasing their value of shares. So actually basically capitalistic purpose, but they're entirely free to depart from that and to add an additional purpose, or maybe to add an exclusively additional purpose, actually, that would turn the corporation into a benefit corporation. That is entirely possible, but that would still remain within the realm of shareholders' approach. Only shareholders exercise their autonomy to choose such purpose. And the last 2 questions from Professor Chulinovich-Herz and from Christian, they overlap a little bit, so I would try to maybe even jointly answer them, maybe with certain differences. So in our view, it is very important to separate 2 different levels. One is the level of autonomy of persons who establish a company, basically shareholders. They can choose what to do with that company. They're free, and their expectations should be taken into account. This is the level of private law autonomy. The other level is the level of public regulation, if you want. And this is where the state, public authorities step in, and they say that they want from companies something, certain levels to be achieved. And in their nature, they're different. First one is freedom and autonomy. Second one is a regulation. And in our view, stakeholders are much better protected by that second regulatory system, where state steps in and says what it expects from companies. And now, to be a bit more specific, Christian asked me about the difference between corporate purpose and corporate goal. I'm not sure that I see that as a difference for 2 reasons. One is statutory text. There is no, I believe, firm, although Commercial Companies Act mentions both terms, aim and purpose, I do not believe that there is a firm ground for differentiating those terms. If we add an additional term, we would simply make more chaos, to simplify. So what would be purpose, what would be aim? So in our view, purpose, or if you want aim, is what shareholders choose, or we have to presume that they choose for their company, and everything else basically is compliance. So of course, and also the example that is mentioned in the question, when Croatian government, Republic of Croatia, it can act in 2 different roles. It can act as a shareholder in state-owned enterprises, but it can also act as a public authority. If it acts as a public authority, then this doesn't have to do much with company purpose, we believe. This is simply a matter of taxation or of putting something of compliance function to the companies. And what Professor Chulinovich-Herz asked, and is very interesting, the role of directives and European law, especially a corporate sustainability due diligence directive, actually proposal. Well, to be very direct, I do not believe that the European Union has an authority to influence company purpose. To be very precise, when you read the Treaty on the Functioning of European Union, if you read, for example, Daily Mail decision, it is quite clear that companies are creatures of national laws, and corporate purpose is the very core of a company under a national law. I do not believe that unless we changed all those instruments, European Union can intervene in company purpose. Of course, European Union can require many things from companies, but I do not believe that this changes their purpose. This only puts an additional requirements. For example, companies have to pay taxes. Companies have to basically protect environment and human rights. Of course they have, but this is not their purpose. For example, I too protect human rights, at least I hope, and I try to be environmentally friendly, but this is not my purpose. I wouldn't call it in those terms. And if we read the text of the proposal, there is admittedly one provision, I believe it's Article 25 of the proposal, which could be read that it wants to influence company purpose. It is a bit ambiguous, and you could also interpret it the other way around, but this is the only provision which could, if you wanted, be understood as influencing company purpose. All the others put some mechanisms of due diligence in order to monitor human rights breaches. In my opinion, this is pure compliance. Why not? I have really nothing against that, to once again reiterate. But I do not believe that this changes company purpose. And just to make a final point on that, why is it important to distinguish those two concepts, company purpose and compliance? Compliance is something that every company has to comply with. But once you comply with that, you're actually free to choose your own strategy. Let's say two examples. One company is very wants to cater the environmentally conscious customers, and it really does everything in order to be ethically at a maximum. But probably its products will be more expensive. This was its strategy, and its customers will buy those products, and that's perfect. This is something close to so-called enlightened shareholder model. The other approach, which is also possible, is for a company to comply only with minimum compliance requirements, and actually, apart from that, to not be too environmentally friendly. In that case, the company will probably have cheaper products, and it will cater to a different sector of customers, to people who are less well off. So basically, and I'm really concluding with that, what we proposed actually enables us to bring clarity into this sea of regulation that exists now both in Croatia and in the European Union. Thank you, and sorry for being this long.
Okay, thank you, Anton, for clarifications. I don't know if Professor Chulinovic hears, or Christian, who started this conversation, has something to add. Please go on.
Actually, Anton and I were already discussing this in late September, so I just wanted to see that in written, but okay, or spoken out in front of the whole audience. So thank you, Anton. I get it. Thank you.
May I pose a question?
Yeah, sure, of course.
Anton, can you just share just your opinion? How do you see the changes in French law, for example, where they have supplemented their code with, if I'm correct, Pacte Statute, where they have regulated that each company now must be managed in furtherance of its corporate interest, and taking into consideration the social and environmental issues which are arising from its activity. So this is now obligatory, or this is applicable to all forms of partnership or public or private corporation companies that have been supplemented by this so-called Pact Statute. So do you think that will possibly this also become a sort of necessity to introduce in the Croatian Company Act? Because probably, I don't know, maybe quietly and with certain articles, we are implementing sort of issues that you have mentioned. For example, shareholders voting on the remuneration policy, which was seen as unimaginable and as a sort of interaction within the capacity of the shareholders. So we are seeing that as Edita mentioned, with regulatory changes on the level of the EU, we are seeing that probably in the future there will be need for some also intervening into the companies, Croatian companies there. However, I'm not, I said yesterday, I'm somewhere in the middle between the shareholder and stakeholder approach, because my reasoning is that really the surrounding in last 30 years have changed so much that we had to foresee other issues also when we speak about the company. So, and for example, in Croatian Code of Corporate Governance, which is also adopted by Zagreb Stock Exchange and HANFA, Croatian Financial Agency, there is also written some obligations which are, let's say, new and which have not been in the Code of Corporate Governance when it was firstly adopted. So just your comments, how do you see the further development? Thank you.
Thank you. Zvonimir, if I might directly answer.
Sure.
Thank you for the question, Professor Horak. Well, so of course we have Code of Corporate Governance, which mentions stakeholders very clearly. And I would dare to say, maybe a bit provocative, but that this whole issue of stakeholders and even ESG, this has been become quite a trend, and many CEOs are mentioning it. But often it seems to me that this is more of a lip service to something that sounds trendy and you want to sell towards the audience than something of a real weight in terms of company law. First, it is of a great question whether directors can change company purpose. They do not have mandate to change either statutes or the article of associations. Of course, they can state that they take into account stakeholders, but only, I believe, as a part of their strategy how to achieve corporate purpose. This is what I mentioned under so-called enlightened stakeholder model. For example, I'm a director and I want to place my company to market it as an environmentally friendly company. And this is completely okay, but this is my strategy freely chosen by me and I'm free to market it. But I wouldn't call that a necessary company purpose for every company. I would call this a legitimate approach how to ensure the interests of shareholders. Because if people recognize one company as being environmentally friendly, they might buy its products more than they did before. So this is perfect. And I'm not sure that, to be honest, I'm not sure that company purpose needs to be changed. I'm not sure that there is a fundamental problem in it. Yes, there might be a problem with capitalism, if you want to be blunt, but I'm not sure that you want to mend it through company purpose. And because company purpose is something much broader than capitalism. As I mentioned, it doesn't have to be financial if people choose something else. If you ask me on a very basic fundamental level, this has to do with freedom. If you want freedom not to be the best person possible, to comply with the minimum that you have to comply, and then you choose to be a mediocre person or even a ethically bad person, so to say. You have the right to do that, and companies have the right to do that. You do not have to be the best guy around. So yeah, basically that is my opinion. Yeah, thank you.
Okay. Anyone else? Question for, I don't know, other speakers? Or perhaps if other speakers want to add something to their speeches. I was quite strict with time, so maybe I interrupted someone, Michaela, perhaps, or someone, if there's anything else to add.
Thank you, Zvonimir, but there is nothing else that I would like to add. I'm enjoying this discussion, but currently I do not feel the need to actually add something, but perhaps just one point. So yes, I totally support this discussion and the arguments set by colleague Bilic, I agree. But then again, as we said, we cannot call it the shareholders' approach, but if shareholders agree to all of this in their articles of association, but then they have some other instruments on hand to again influence everything what they said, where are we going to put that? Where are we going to put their private ordering? Is it a stakeholder or a shareholder approach? What is that? Where does this belong into entire discussion regarding the corporate governance? This is something which actually bothers me. So I don't know. Probably it goes in the line of thinking, of course, shareholders' autonomy, of course, private ordering, will of the parties, and so on. Should we put a limit on that as well? Some additional, except those strict corporate limitations or limitations of general obligations law, everything what we as lawyers say. Do we need to expect from shareholders when they're actually engaging in a contract to adhere to the duty of loyalty towards the company, towards each other, towards any third party? I mean, it's actually a new line of discussion that could be developed. I only perhaps want to address that it's actually possible to discuss even such a matter, which is not in the focus, but definitely goes in line with it. Yeah, thank you.
Yes, just maybe a short comment. Maybe this was a more comment than a question. Of course, I simplified a little bit with this private freedom versus public regulation. It's not that simple. Of course, let's say shareholders have to, as you mentioned, comply with their duty to loyalty, but loyalty towards the company, their duty of loyalty derives from their contract. It's basically the same. If we enter into a contract of sales, I have to abide by that contract. But this is still within the realm of private law. And of course, if shareholders choose to change their corporate purpose, to amend it, to write it explicitly in the article of association, I really believe this is a great option, which is perhaps too rarely used. I actually advise that now new law SOEs is actually being made, and I believe this is a great way to regulate SOEs through articles of association. State in the purpose of the company that you are not exclusively for profit, that you have an additional purpose. So this is really a good strategy, I believe. But I really believe that it is very important. You have so many tools at your disposal, but it's very important to be precise with those tools, to use the correct tools. We have all the tools. Well, maybe not all, but many tools at our disposal: private, public, company law, different legal sectors. I really do not see the need to cram every political need into the poor notion of company purpose. It becomes overloaded and too vague, and you can do nothing with it in the end. So, yeah, thank you.
Okay, anyone else? perhaps I should spice up a bit this discussion. Well, in general, I agree with you, Anton, but in fact, there is one little disagreement, perhaps, I would like to point out, and that is that you said that the purpose of the company and the goals of the company are the same thing. Well, in fact, I don't think so, because the purpose of the company, in my opinion, is what is the company used for. If we look at the company as a tool, I think the purpose of the company is very, very directly stated by the legislators. The purpose of the company is, in my opinion, making the profit, organization that is architectured for making the profit for its shareholders. That is the purpose. We can, of course, use the company, in my opinion, to achieve that within that purpose, or in some other way. I don't know. Of course, the Company Act gives us the possibility to achieve some other goals by company, but then again we have other entities that are perhaps more suitable for those other goals, and the goals are something that is imposed by the members or establishers of the company. So there is something. Well, maybe I should simplify this. So, what is the purpose of, I don't know, chair, perhaps, to sit on it? Yes, but we can also use it the other ways. So, but that doesn't change the main purpose of the chair, right? Why are we getting the chair, buying the chair? It's something else. Is the goal we want to achieve with this chair. Okay, that would be something.
Can I just comment on the chair part?
Yeah.
I don't want to go into detail. So in my analogy, the maker of the chair would be shareholders. They imagined the purpose and they made the chair. And the person who abuses that chair would be a director who doesn't do his duty well. He sits on the chair in a very wrong way, and this is not what the originator, the maker of the chair, actually had in mind.
Well, I was pointing that the maker of the chair and the giver of the purpose of the chair is legislator, and the user of the chair is are, of course, shareholders. And how will they use the chair? It's up to them. So they can achieve different goals with the chair. Either they can just sit on it and use it as it is supposed to be within its purpose, or they can use it, I don't know, for other things.
You can always sit on two chairs.
I'm sure this analogy was good. Okay, Christian.
You can always sit on two chairs, right?
Sure. Okay, I'm not sure if there's anything else to add. Any other comments or questions, perhaps? No? Okay. Well, thank you everyone for this discussion. If there is nothing else to discuss, I would conclude the only reasonable, I would give the only reasonable conclusion, and that is that it is time to finish this session. And in that spirit, I'm closing the session.